Creating an official and legally binding last will and testament in Mississippi may seem intimidating at first. However, wills can be made rather simply and, most importantly, often without an expensive lawyer, if provided the right guidance. In this video, we'll cover the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Mississippi, and how and where to create an official will. Let's begin. Wills and their importance. A last will and testament, also simply known as a will, ensures an individual's estate is properly handled upon their death. Wills set clear instructions on how to distribute the deceased assets among their family, friends, and other beneficiaries. It's highly recommended for adults to have one in place, particularly those who are of advanced age or suffering from fatal health conditions. But now, what occurs when no will is left? A person who passes away without a will loses full control of who inherits their property. Instead, Mississippi law will determine how the deceased assets are dispersed. Typically, their spouse and/or children inherit the property through a set formula, but it varies. In some cases, loved ones may engage in disputes regarding who is the rightful heir to certain personal or real property. It's best for the will maker to set instructions in writing by drafting a clear will, which in many cases doesn't require an expensive attorney. A person of sound mind can draft a will in Mississippi with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will manage the estate accordingly, the names of all beneficiaries, and a thorough list of assets each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's go over some legal requirements in Mississippi. Last will and testaments in Mississippi must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 trusted and competent witnesses. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to the trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for Mississippi that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.